Igbo ọma na-ege ntị, ekeneni m unu ọzọ n'ụbọchị uhuruchi nke taa. Asị m nke echiri ya zelu. Asị m ndị be anyị ụbọchị nke taa ya dịrị anyị na mma. Na ya dị ka echi na echi ada agwụ agwụ. Otu anyị kwuru otu akwa ya dịrịrị. Ise. Dịka o si dị, ebe anyị si na-ewetara unu ozi ya bụ na Eastern News 24. Dịka anyị si kwuo nkwa na ị ga na-agba mbọ na-ewetara unu any update ọbụla bụ gbasịta maka ihe na-eme na obodo anyị nọ n'ime ya. Ana gbasịta maka nwere onwe ndị Igbo na-azọ. Efe anyị kwuru nkwa na ị ga na-ewetara unu update n'oge ọbụla n'iru akwụkwọ. Dịka o si dị, o were nwanne anyị nwoke were ịgwa anyị n'iru akwụkwọ n'ụbọchị uhuruchi nke taa. Mma achọ ka ị gee ya bụ ife bụ nnukwu, ọ dị mkpa na ọbụla bụ onye Igbo ya ege ya. Ị ga-esia ya ikwuo ife i chere gbasịta maka ihe ndị a niile okwugasị n'iru akwụkwọ. Unu mụ anyị na-ekwu maka ya, achọrọ m ka anyị kpọọ okwu afa, mana mma achọ ka anyị gee ya bụ ife. Ị ga-esia ya drọpụrụ anyị kọmentị gị ife i chere gbasịta maka ihe ndị a niile okwu. All right, over to you, sir.
He's the leader of the indigenous people of Biafra, IPOB, Mr. Nnamdi Kanu, from detention. The Supreme Court ordered the continuation of the trial bordering on terrorism preferred against Mr. Kanu. And in a unanimous judgment prepared by Justice Garba Mohammed but read by Justice Emmanuel Agim, the 5-member panel of justices say the federal government acted, in their words, irresponsibly when it forcefully brought Kanu back to the country from Kenya against all known laws. However, the Apex Court held that it was not enough to divest the trial court of its jurisdiction to continue with the case. Let's take a listen to the counsels.
We had hoped that it would come our way, but it has gone the other way. It simply means that we have to go back to the High Court and get done with this quickly. We still have hope. We're not in despair.
By the grace of God,
yes, so
victory is assured.
Yes, we will. We will lose a little time. We still have to go back. That's all it means. But I'm very consoled by what the Supreme Court said, that he ought not to have been treated the way he was treated. His bail ought not to have been revoked. His home ought to have been invaded. All that is a consolation to us. So we have hope.
This is victory to our administration of criminal justice, because it shows that once you are an accused person, once you are a defendant, no matter what excuse you want to bring to hide under the law to say that you should not be tried, the Supreme Court have expressly, unequivocally stated clearly that we don't have the legislation that will vitiate the court from trying a defendant that has committed a crime. You must be tried for every offense you have committed. You saw that the court came very heavy on the security agencies where they have in any way, impaired on the rights, the fundamental rights of the defendant. However, our laws have made very clear provision for remedy where there's such infraction on the right of the defendant. Then you can such a defendant can go to the civil court and then seek for civil remedies for the violation of his fundamental rights. And that is why, of course, we have the fundamental rights enforcement.
Now, the councils were not the only ones that reacted to that judgment. The governor of Anambra State, Chukwuma Soludo, also says he respects the rule of law, but believes a political solution could also be considered in this particular case.
I am a governor who believes in the rule of law. And in the country today, when the Supreme Court speaks, that's final. And the Supreme Court, in its wisdom and judgment, considered that he should go for a fresh trial. We can only say, we don't question that, we don't challenge that, we'll just say the rule of law will prevail. And I think that will go through its judicial process. For me personally, and as everyone knows, that I've been aware of the judicial process. But in spite of that, I have persistently and consistently called for a political solution to this issue.
Now, there's a lot to talk about when it comes to this particular case between the leader of the proscribed IPOB, Nnamdi Kanu, and the federal government. I'm going to introduce my guests, two senior advocates of Nigeria, in a moment. But let's walk you through some very simplistic way on how we got here in the first place. So first, Nnamdi Kanu was rearrested in Kenya and extradited to Nigeria by the federal government in June 2021. Now, he was arraigned at the Federal High Court Abuja before Justice Binta Nyako on an initial 4-count charge of treasonable felony, conspiracy to commit treasonable felony, terrorism, illegal importation of radio equipment, and defamation of the character of former President Muhammadu Buhari. Now, the charges were later amended to a 15-count charge on terrorism and membership of the proscribed group. Justice Binta Nyako at the trial court had in her ruling dismissed 8 out of the 15 charges, saying that Mr. Kanu had questions to answer in the remaining 7 charges. Of course, Kanu was not pleased, filed an appeal on the remaining 7 charges at the Court of Appeal. The court agreed with Kanu and struck out the case, and by implication, is free to go, and the learned silk will explain all of that. But the FG swiftly filed a stay of execution. Another panel of Court of Appeal Court Justices sat and upheld FG's stay of execution. Now, the FG appealed to the Supreme Court on the quashed 7-count charge, insisting on continuation of trial at the Federal High Court. Today, the Supreme Court sat and agreed with the federal government that Kanu should go back to the Federal High Court to defend himself. However, the Apex Court frowned at how Kanu has been handled or treated by the federal government, but is at liberty to file a civil case against the federal government. So just a round-off or some kind of a sequence of how we got here in the first place. So my guest to explore all of these issues, Senior Advocate of Nigeria, right here with me in the Lagos studio, is Mr. Wahab Shitu. Thank you so much, sir, for coming on the program.
Thank you for inviting me.
And also joining us virtually is another Senior Advocate of Nigeria, Mr. Paul Ananaba. Mr. Paul Ananaba, thank you so much for coming on the program.
Thank you.
All right. Let's start with you, sir. I'm sure you're quite familiar with this case, and just a legal perspective of what transpired today at the Supreme Court.
Well, the Supreme Court has pronounced, and essentially, the pronouncement of the Supreme Court can be categorized into 3 main aspects. The first aspect of the pronouncement, which is decisive, is that Mr. Nnamdi Kanu is requested to go back and be arraigned on respect of the 7 counts, to go and face his trial in respect of the 7 counts earlier decided by the trial court. That's the first one. The second question, which is also very instructive, is to also say that the federal government can be, the way the federal government handled the deportation of Mr. Nnamdi Kanu outside the country to come and face the trial, offense against best practices, actually slammed the federal government for the way and manner it handled the deportation. And also cautioned that is likely to affect, that the federal government henceforth ought to be aware, ought to be sensitive about its image, locally and internationally. That's also a strong indictment. The third one is to say, the bail, that it was wrong of the trial court to have revoked the bail of Mr. Nnamdi Kanu following the invasion of his residence by law enforcement agents. So those are the 3 key aspects. But as it is now, what is significant about the pronouncement of the Supreme Court is that Mr. Nnamdi Kanu is now requested to go and face his trial. Now the question you want to now say is, okay, that is what the Supreme Court has decided. And once the Supreme Court has spoken, that's the final court. There's no appeal. You cannot appeal against the pronouncement of the Supreme Court. That's the law. And I must also say that the Supreme Court correctly interpreted the law. Because it's just like the analogy one can give to this is the issue of stolen evidence. If you steal evidence, which is relevant in a court of competent jurisdiction. The fact that that evidence is stolen does not derogate from its admissibility. So you cannot say because the evidence was stolen, then it is not relevant. That's Section 14 of the Evidence Act. So as far as the law is concerned, the Supreme Court, the apex court, has correctly interpreted the law the way it should be interpreted. But the question that we should ask is that how do we deal with the Nnamdi Kanu situation? I'm in favor of a unified country. I'm in favor of a country that is united. A country that will... The Nnamdi Kanu situation must be handled very carefully. And this is a new regime. I'm in favor of taking a closer look, notwithstanding the case as pronounced by the Supreme Court. It's a very sensitive case. The governor of Anambra State mentioned the issue of adopting a political solution. I think that also should be on the table. Yeah. But I said you want to stop me here because I have some other, clarifications I want to make. But I can. But
on the case, right?
On the case.
Yes, but we're going to come to some of the things you're already speaking about. But I wanted to get the perspective of Mr. Paul Ananaba. Mr. Paul, I'm sure you've had the perspective of the learned Silk, your colleague, on this particular issue. I don't know what your interpretation or your perspective is as far as what transpired at the Apex Court is concerned today.
All right, thank you. Wahab Shitu, my brother, I agree with you. I agree with Wahab Shitu largely to say that the Supreme Court is final, not because it is infallible. It is infallible because it is final. You have given a rundown of a run-off to where we are today. Really, the expectation of many Nigerians, it was clearly that Nnamdi Kanu will go home a free man today. So it is that may have thrown this to the front burner. And I go further to say that this case does not turn only on law. If it turns only on law, then it would have been a different thing if it was turning only on law. It is both law and security. It's so sensitive, particularly for those from the southeast and some other people who believe in the cause of Nnamdi Kanu. When you take that into the international law balance, you begin to talk about whether an act by a group that are asking for self-determination is a crime or not, even starting with the OAU Charter and down. So you see that in Africa, we begin to look at the jurisprudence of the fact that because we needed independence, then some of those acts will be considered not secession or treason or treasonable felony, but really self-determination. So what I want to draw from that is, yes, the Supreme Court has made the point that the decision that, yes, contrary to the decision of the Court of Appeal, that Nnamdi Kanu should face those 7 charges. Remember, the Court of Appeal has dismissed those charges. But the Supreme Court also made the point that the federal government was wrong in the way they handled this. Now, asking a person who has been in detention for all this while and whose detention is causing some discomfort to go back to a civil suit whilst in detention is of concern to me. I believe that the Supreme Court had all the powers, has inherent powers to take any decision in the best interest of the country. It's actually a policy court. So my expectation would have been, having found that the way the arrest was done wasn't approved by the Supreme Court, having found that the invasion of Nnamdi Kanu's residence and all that wasn't acceptable, I had expected that, yes, Nnamdi Kanu should stand his trial, but the Supreme Court also had the right and the powers to have granted him bail upon certain conditions. That way we de-escalate, because law is an instrument of social engineering and re-engineering. And I want to agree with Governor Soludo that perhaps it is now time, now the Supreme Court has spoken, that even revocation of the bail was wrong. If the Supreme Court had found that when the Supreme Court found that that bail was wrongly revoked, I believe that the Supreme Court would have made consequential orders, even in that respect, to say that that bail be restored. But Nnamdi Kanu will now be expected to go to court again to ask for restoration of bail. You see, the psychological content of law is important, so that a reasonable man will see that justice is not even delayed. I don't know how long it could take to file such applications. That's my concern. But the Supreme Court, I agree, was right in saying, okay, since we are set aside the portion of the 7 counts, go and defend this, the 7 counts before the Federal Court. But meanwhile, since your bail was wrongly revoked, your bail is restored on these conditions. Those are my perspective. However, the position of the Supreme Court remains the law and will continue to be the law. And I urge that every Nigerian should respect the decision of the Supreme Court and follow through rule of law. All I've said is my expectations. But
all right, Mr. Ananaba,
whatever the Supreme Court
Mr. Ananaba, if I can butt in, so I can come back into the studio. I'll come back to you, Mr. Ananaba. Mr. Shitu, I was listening to some of the things you were saying, and then for those who are not legal minds like yourselves and who want to understand why, the reason why he appealed in the first place is because 8 was quashed and they sustained the other 7, and that same court is where it's going back to. They will be wondering psychologically, what will be his expectation from that particular court at the end of the day? I don't know whether I made that question as plain, as simplistic as I can.
This is not how the criminal justice system works.
Which is why you need to educate us.
When you are arraigned for a specific number of counts in a criminal trial process, in this case maybe 15 or 20 counts, and at the end of the trial process, I mean after the prosecution has led its case, or you file an objection to the jurisdiction of the court to entertain the charges, if the court finds, based on the evidence or the proof of evidence, that some of the counts are sustainable, then you will say that you have a case to answer. And those ones that are not sustainable, the court will say, oh, you are discharged and acquitted in respect of those counts, which is what the court has said here. The fact that the court has said you have a case to answer is not conclusive of guilt.
Okay.
It's saying that, oh, come and offer explanations to clear some gray areas in order to be able to either prove your innocence or your guilt. So the window, that does not distract from the fair hearing, mindset of the trial court. And all lawyers know this fact. In a criminal trial, you have an option to allow the prosecution to call all its evidence And then at the end of the case, when it is your turn, you either elect to defend and meet the case of the prosecution, or you choose to make an application of no case. In which case, arguments will be taken in respect of your application on no case submission, and the court will give a ruling in respect of each of the counts, which is what the court has done here. 8 of them were dismissed, 7 of them were upheld. He felt dissatisfied, and he appealed. The Court of Appeal agreed with him. But unfortunately, the Court of Appeal is not the final court. The state also appealed against the decision of the Court of Appeal. And the Supreme Court has today said, oh, go back and face your trial in respect of the 7-count charge. So what the Supreme Court has done is consistent with the law. Because, you know, the Supreme Court is a court of law, is a court of justice. It's also a policy court. At that level, all issues, the records, everything will be considered. And you can see that the Supreme Court examined all the issues and made pronouncement. They examined the question of his illegal, deportation, and pronounced that that is clearly offensive, and that henceforth our country should be conscious of his image locally and internationally. That's a strong message coming from the Supreme Court. And secondly, when security agencies invade the premises of a suspect who is on bail, the trial court was not entitled to now revoke the bail after the man fled for his life. Again, that is a very strong statement. So on all issues, the Supreme Court has done justice to the matter. When somebody is alleged to have committed any offense, it remains an allegation.
Yes, sir.
He has the right to prove his innocence or guilt in a fair trial process. And then what we should advocate here are several options open to the federal government.
I was going to that because of time. So, because you have to look at it, this vis-a-vis the tension that has enveloped that region of the country where it comes from. We have the issue of IPOB, sit at home, and all of that. So, with all of this decision, I want you to put in perspective, what is the way forward?
Well, the way forward is the rule of, one option is the rule of law option, which is to say, if somebody is alleged to have committed an offense, he should be allowed to go through the trial process, subject to the guarantee of his liberty. In this case, release him on bail, allow him to face his trial, but don't, while he's facing his trial, don't tamper with his liberty, subject to assurances that he will make himself available, and subject to assurances that he will not commit any further offense, alleged offenses. That's one option. The second option that government can look at, in the spirit of unifying the country, government may look at the exercise of powers of the Attorney General under Section 174 of the Constitution that empowers the Attorney General to look at the case and decide whether in the overall public interest it is desirable either to continue the prosecution or discontinue the prosecution or enter a nolle, terminate the proceedings. The Attorney General can exercise that. But in exercising those powers, he has to have regard to public safety, public interest, paramount.
So are you saying, just so that before I go to Mr. Ananaba,
I'm saying that all options should be considered.
So what I wanted to ask is, what advice, in case the federal government comes forward, what advice will you, if you have the chance, to give to Nnamdi Kanu to in terms of the agreement you should come up with the federal government? First of all,
Nnamdi Kanu must, because federal government is concerned about terrorism. Every serious government, allegations bordering on terrorism is a serious allegation. He must be prepared to renounce all, acts, or alleged acts of terrorism. He must give an undertaking. He must be ready to say, he must also give an undertaking to make the peace. To ensure that, because peace is also very important to the federal government, because in the interest of the peace building process, federal government might want to engage elements who are close to Nnamdi Kanu, including governors from that region, to be able to see whether this matter can be amicably resolved in a manner that will not threaten the peace process, in a manner that will ensure that further acts of terrorism in that region or anywhere are not, anticipated or perpetrated.
Good point. Let me come to you, Mr. Ananaba. as we begin to wrap up, this similar question I asked the Leonard Silk as well, just like you. We have to look at this broadly in terms of national security. If you were to advise both sides, both the federal government, he is giving some advice, both the federal government and Nnamdi Kanu and his team, what exactly would you be telling them just for us to have this national peace and move forward as a country?
Carlo, the Supreme Court has given a decision, and that is the final decision on that point. That is, you are still innocent. There are allegations against you. There are 7. Go and defend it. You had a bail. The judge revoked it. That revocation is wrong. Go back and take due process and ask for your bail. Supreme Court has already said that you are clearly more or less entitled to a bail. Get your bail, prepare your defense, and face up this charge. That is Nnamdi Kanu. For the federal government, I think that the country has so much concerns and worries that this matter ought to be looked at now after the pronouncements of the Supreme Court, showing that this has affected our image abroad, it has affected our image in Nigeria, invasion of property and fundamental rights of Kanu and even the family, beyond even him. So at this point, I think that the federal government should also take a reconciliatory position. And we will achieve more in the country if Nnamdi Kanu's case is taken out. But as a responsible government too, they should look for some guarantees. Since Governor Soludo has come up to say political solution is there, that can be looked at. And like my brother Shitu said, there are several options. The federal government can withdraw the charge. The Attorney General can enter a nollie and bring the case to an end. And it shouldn't be treated in such a way as if Nnamdi Kanu has been convicted and is now asking for a reprieve. No. Our constitution says that Nnamdi Kanu, even at his detention for all these periods and all that, is still innocent until proved guilty. That should not be denied him. So I look forward to him Nnamdi Kanu going on bail.
Right.
I look forward to his also showing patriotism by ensuring that further issues do not arise from the way he will go about his affairs until this trial is done done with. So what am I saying? It's important.
Leonard Silk, if I may button, that would be a great place to conclude our thought. Thank you so much for your time. We're totally out of time. So my sincere apologies. Mr. Paul Ananaba, Senior Advocate of Nigeria, joining us to speak on this recent Supreme Court pronouncement on Nnamdi Kanu's case, joining us virtually. Thank you so much. And also here in the studio in Lagos, Mr. Wahab Shitu, Senior Advocate of Nigeria, for your very insightful thoughts on this. Thank you so much, sir, for coming.
Thank you so much for inviting me.
Thank you.
And the Baidalo Linen Kunisnes Nirapo. Edeke Isowe Gaya Bife, Enoria the Ballon, the Gentle Lion who was in Irapo, no Basink Tatano. Ozo the Kibiabo. Kefi wari kubastama ya bifenda ni no kugasinirwa kuko foku lidinne okura kosi di kefi wari kubastama ya bifa drop ya on the comment section below chitekwe ya Eastern News 24 kaisi wene hotel no pozi ya dokempa dano no munde mgwan kemesian.